earlier. I want to go back, Mr. Addington, Mr. Yu, to the line of questions I pursued earlier because the clock cut us off before I had a chance to make some points I want to make. A lot of what we're talking about today, Professor Yu, is the interpretation of a statute. You've conceded that there was a relevant on-point anti-torture statute in place in early 2001, 2002. It was passed by Congress. You've correctly pointed out is not at all unusual. There wasn't a massive amount of legislative history. I questioned you earlier about why it would not have been helpful or important for the administration to reach out to the body that drafted the statute to get its own interpretation of what the words meant. Mr. Addington, I think you were telling me at one point, or you were conceding that Mr. Specter, the Republican chairman of Judiciary, wasn't consulted, Mr. Sensenbrenner wasn't consulted. Tell me, sir, why it would not have been helpful for the Bush administration to have reached out to the congressional leadership, even of its own party, to ask what the statute meant.
Sir, you asked that question earlier today, and I would give you the same answer. Actually, as a legal matter, I think you're wrong, and that doing so would be irrelevant.
No, I didn't ask you as a matter of policy.
That's different. Okay, as a matter of policy, that can be different. As a practical matter, back when all this first came up, say, I'm not sure exact time frame, let's say the year 2002, these were highly classified. This was a highly classified program conducted by the
No, sir. Very simple question.
Yeah. I'm explaining to you why some members knew about it. Let me
reframe my question then and perhaps make it a little bit easier, sir. All I'm asking, I'm picking up on the analysis Mr. Yu makes in his opening statement. He talks about a particular interpretation of the anti-torture statute. And Professor Yu says that he believed that the anti-torture statute was a subjective test that depended on the physical and mental condition of the individual being interrogated. That is an interpretation of Congress's intent. I happen to think, sir, from a policy standpoint, as well as from a legal standpoint, there were two options for the people you work for. They could have come to Congress and they could have asked for the statute to be clarified. They could have asked for new powers. You all did that with respect to the Patriot Act. I suppose theoretically the Bush administration could have said we don't need a Patriot Act. We're just going to assume that we have some plenary executive power, but you didn't do that. You came to Congress and you asked for new intelligence gathering, new information gathering capabilities, and the Congress gave it to you in overwhelming bipartisan fashion. Authorization of force. You could have said there's some plenary executive power to protect the United States using all means necessary. You came to Congress. All of those things involve potentially confidential classified matters. Was there even anyone in the executive branch who advocated, Mr. Addington, coming to Congress and asking for a new torture statute?
Well, of course, I can't answer for everyone in the executive branch. I don't know what they thought about.
Did you advocate it?
As for me,
that's a simple yes or no. Did you advocate it?
I don't recall advocating that to anyone, and I wouldn't today.
Just a simple yes or no. Do you know of anyone, Professor Yu, I include you in this, do either of you know of anyone in the executive branch or the Department of Justice who advocated coming to Congress and asking for a new statute? That's a simple yes or no.
On the subject of interrogations?
Torture, the definition of it.
No,
Professor Yu, do you know of anyone who even advocated coming to Congress asking for a new statute?
I don't remember anyone doing that.
Do you know of anyone who advocated going to the House and Senate Intelligence Committees and asking for their judgment as to what the torture statutes meant?
No, and I wouldn't recommend that. I'd recommend going where the law requires, which is OLC.
And this is the problem, gentlemen. If your administration had come to what was a Republican Congress and gotten its imprimatur for your definition of torture, you would have shared responsibility. If you haven't figured it out by now, one of the critiques that a number of members on both sides of the aisle have of the way you all have done business is, frankly, you haven't shared the responsibility of making the decisions. Sometimes you've had to when the Supreme Court's told you you had to with respect to tribunals and FISA. But frankly, on your own, you've never done it. And I would submit that that is the core thing that this committee ought to be focused on. A policy that was derived by the executive branch. You didn't even feel the need to even consult or to share your thoughts or your analysis of congressional intent with Congress. It's left you now with a policy that has only your fingerprints on it. It's left you with a policy with which the executive branch the legislative branch was completely cut out. That is a very negative legacy for your administration.
You're leaving one bad implication on the record, which I want to clear up is not accurate, which is it sounds like you're implying that the House and Senate Intelligence Committees didn't know anything about the CIA program.
No. I'm talking about your interpretation of the definition of torture. You're not suggesting the House and Senate Intelligence Committees knew about the interpretation of torture that Mr. Yu advanced in his opening statement, are you?
At some point they did. I don't know when.
Would you tell us that point?
Sorry? I said I don't know when. I'm fairly confident that these discussed and they've held a lot of hearings on it, but I don't know when that first occurred.
The time of the gentleman has expired. I now recognize for 5 minutes the gentleman from North Carolina.